Each state has its own requirements to be able to file for a divorce. The following are some of the terms or information you need to know. Residency. You must file in the state where you live. Each state requires that you live in that state for a period of time before you will be considered a resident in order to qualify to file for a divorce. Each state has its own requirements, and usually residency requirements cannot be waived. Typically, a state will require that you live in that state for 6 months to a year before you can file for a divorce. However, it is very specific to each state, so check with an attorney regarding a residency requirement in your state. It is helpful to have a local driver's license, voter registration, tax returns, real estate deeds or leases, proof of where mail is received, and receipts from stores and restaurants in order to prove that you live in the state in which you are filing for divorce. What happens if you have not lived long enough in the state to file for divorce? If you have not lived in a state long enough to be considered a resident for the purpose of divorce and your marriage is in trouble, most states will allow for you to seek relief in other ways. The divorce may not be an immediate option. An action for temporary child support, temporary alimony, and temporary custody are. What if you and your spouse live in different states? If you and your spouse live in different states, a court may have to make a factual determination as to which state has authority to grant a divorce. Generally speaking, the last place you lived with your spouse will have jurisdiction over the marriage unless both parties have moved away from that state. Do I have to file for the divorce in the county where we live? Some states require that the divorce action be filed either in the county where the parties were married or in the county where the person who is being sued for divorce lives. The legal term is venue. Some states allow for the parties to agree to a venue other than where they live. An example of a reason to file the case in another county would be if the parties desire to maintain privacy. If you file in the wrong county, many states allow for venue to be transferred upon an application to change venue. Venue can be waived in some states. What role does fault play in a divorce? The vast majority of states now have no-fault divorce, meaning that you can obtain a divorce simply due to irreconcilable differences. No-fault divorce means that neither party is required to prove that the other person committed a bad act in order to justify a divorce. A word of caution: just because a state has no-fault divorce does not necessarily mean that fault or conduct would not be important on economic issues such as alimony and property division. Also, fault and conduct can have an impact on a custody case if the issue involves matters that affect the best interest of the children. What are the typical fault grounds of divorce? In the states that do require grounds for divorce, the grounds required include cruel and inhuman treatment, adultery, desertion, and abandonment.